Hello and welcome to this session of the Kentucky Refugee and Immigration Inclusion Summit on Workers' Rights for Immigrants. My name is McKenzie Cantrell. I'm an employment law attorney for Kentucky Equal Justice Center, and we're going to tell you a little bit more about Kentucky Equal Justice Center. We call it KEJC, and in a moment, but co-presenting with me today is Miranda Brown, our outreach coordinator for KEJC. And we're going to go back and forth today, talk a little bit about different employment rights and that you all might have, or that someone you know might be going through, and really give you an idea on when to talk to an attorney and when to sort of, what they tell us in law school is to issue spot. So know sort of what the issues are, know what sort of laws might be affected or being violated when you're talking to one of your clients or a friend or family member. And that way you'll just know when to talk to someone and know, have a general framework of when these laws are being potentially violated. So we're going to get started. We're just going to tell you a little bit about KEJC. So we're a statewide organization. We were originally founded. We've been around for a long time. I've been at KEJC almost 7 years. And at the time, we're sort of like a branch of the civil legal aid societies, what you might know as Legal Aid of the Bluegrass. In Louisville, we have the Legal Aid Society of Louisville, and we are still closely affiliated with Legal Aid. We serve low-income populations, but we actually don't receive the same kind of funding that Legal Aid does. And because we don't receive any federal funding, we have a little bit more of an ability to represent certain groups of people that are prohibited by regulations, by federal law. And we do that. So we have attorneys who specialize in different areas. So I'm the only employment attorney, but we have a health policy attorney. We run the Maxwell Street Legal Clinic in Lexington, which a lot of people don't know that we're sort of one and the same. KEJC and the Maxwell Street Legal Clinic are the same organization. And we also have another attorney here in Louisville that works in public benefits, health policy. He's our managing attorney, so he does a little bit of everything. So we try to be multi-issue and try to cover a lot of the ground that the civil legal aid societies can't do because of their funding. So we've been around a long time and hope to be around for a lot longer. The Employment Law Project specifically does really three things. And we kind of have it in the nice educate, litigate, advocate, rhyming model. But mostly we do presentations like this to educate the community and let you know about different, we have a podcast. We talk about different laws that are being considered. We have episodes on the General Assembly, and we're going to talk about some laws even today that are being considered in Congress. We talk about the general framework now under which we're operating in employment law, and we have topics that cover a lot of different areas of employment law. And then also, if you need specific wage consultations or other types of employment law consultations, we have a free consultation period on the third Wednesday of every month at the Maxwell Street Legal Clinic in Lexington. Because I work in Louisville, I come there every month and consult with potential clients for free. That's a good service that we've provided to the community for a long time. So you can definitely call us, and we have our contact information at the in some of these other slides. So that's one of the first places you can go to for help. Out of some of those cases that we consult on, we accept some of them for litigation. So I'm a typical attorney in that regard, that we do mostly wage and hour, which is minimum wage, overtime violations, and breach of contract. And then we also do some human trafficking litigation. We also work at the state and federal level, and sometimes even the local level, talking about how various policies that are being considered impact the clients that we serve mostly low income and immigrant populations. So it's another very important part of the work we do. And because, because we are around a lot in the community, we know a lot of stories, we know how people are being impacted, and that impacts our other work. So it sort of comes full circle in that regard. Just to let you know, we're going to be talking about a lot of legal sort of technical concepts. And again, I want to emphasize that this is general advice. Everyone's situation is very specific. And again, there are some situations where you are going to want to talk to an attorney. So please I hope this presentation lets you know better of when to do that. And you can always call me at my office if you have a client who's needing advice. And again, this is supposed to sort of give you a general idea of, oh, I remember from that presentation that one day that this person who's talking to me about their problem, this might be related to this. So that's really all this is planning to do, to arm you with some information, but not arm you as an attorney. So we sort of like to give that little bit of a disclaimer.
All right, so you want me to take it from here, McKenzie?
Yeah.
Okay, so I'm our outreach coordinator, as McKenzie said, and I do a lot of outreach in the community about what people's rights are. Of course, right now, this is the way we're doing outreach is by video with some flyering in our radio and podcast. I also help people enroll in health coverage through Medicaid and the marketplace, which is also relevant for a lot of workers. So first off, on topic, we wanted to talk about job termination and unemployment benefits. Job termination is something that we generally talk about in our outreach because you do have rights even after your employment has ended, but it's especially important right now when so many people are unemployed and receiving unemployment benefits. So first off, after you're terminated from a job, one of the things is to review your employer's policies, because in your employer policies, you have specific rights under those policies, and that's going to vary depending on the employer. So those are important even after your job is ended. There are certain things, however, that all employers must do. They must pay any wages that they owe you within 14 days. They must pay for any benefits that they were supposed to give you, or any reimbursements or medical payments that they were supposed to give you because of your employment, also within 14 days. If you had health insurance through your employer, then they must notify you, if they are eligible for COBRA, they must notify their employee that the employee can stay on the employer's health plan for 18 months through the COBRA plan. Though that would be at the employee's choice and the employee's expense. Also, job separation, like I was mentioning about health coverage, job separation is a qualifying event to shop for marketplace coverage. If you had employer coverage and you lost it because you lost your job, then you can go on healthcare.gov and get assistance through an in-person application assister, or by calling the healthcare.gov hotline to get health coverage through the marketplace with the subsidies to help you be able to afford it. So the other important thing, obviously, about job separation is you may be eligible for unemployment benefits. So the standard things that make somebody ineligible for unemployment benefits would be, or unemployment insurance, abbreviated here as UI, is that if there was misconduct related to the work, that could make someone ineligible for UI. Voluntarily leaving a job with good cause attributable to the employer, in that situation, a person could be eligible still for UI. Discrimination and constructive discharge can make an employee eligible for UI, and the employee has to follow UI program rules. However, some of these, obviously, as many of you know, have been waived during the pandemic emergency. So right now, unemployment benefits look a little different than they used to. Normally, you have to follow certain rules to qualify for unemployment benefits, but some of that has been waived. McKenzie's going to hit on some of that in a moment. But additionally, there's a federal law called the CARES Act, and this act has implemented some additional unemployment benefits. So the first point here is Pandemic Unemployment Assistance, abbreviated PUA. And this is benefits for jobless individuals who had been self-employed, independent contractors, freelancers, part-time workers, and workers with spotty job histories who under normal circumstances would not qualify for unemployment benefits. But under the CARES Act, which is currently in effect, they do qualify for the PUA, which is basically a new type of unemployment benefits. Currently, this is set to expire December 31st unless Congress changes it. The second point is pandemic unemployment compensation. So this is $600 extra a week for anybody on UI or PUA, and this is set to expire July 31st. And number 3 is pandemic emergency unemployment compensation. So this is an extra 13 weeks of UI benefits after states exhaust their regular UI benefits. So the state of Kentucky distributes unemployment insurance, but after the normal amount of weeks, you can get an extra 13 weeks of this federal program. And that's for all claimants, not just people who lost their job because of COVID-19. And this is currently set to expire on December 26th.
So I'm going to talk about a state provision that sort of goes along with the CARES Act. Earlier this year, when the pandemic started, the Kentucky legislature was in session, and some of what you're seeing here is a part of the CARES Act. Under the CARES Act, states are not allowed to restrict their benefits in any way while they're receiving CARES Act funding. But actually, Kentucky was sort of a step ahead of some of the provisions in the CARES Act and enacted them pretty quickly, which I think has helped us in some ways administer our unemployment program with that CARES Act money. So a lot, if you know anything about unemployment, you kind of have to throw that knowledge out the window, because a lot of what we've seen during this pandemic has either changed substantially or it's been waived. So normally you have something that's called the waiting week, where you're sort of you're waiting for benefits, but you're also waiting to see if something with your employment situation turns around immediately. Maybe you find another job or something like that. That's been waived. You usually have to be actively searching for work and have to prove that and meet some requirements there, and that's also been waived. We have what's called an alternative base period right now, which basically is a longer look back period that they can look into your work history and make sure that you have enough work credits going back for a certain amount of time to qualify for benefits. We've seen a lot of mass layoffs during this time, and bigger businesses or medium-sized businesses aren't penalized. Sometimes there's certain reporting notices that businesses have to give if they're going to lay off a certain number of workers. And we have groups right now who have historically not been eligible for unemployment insurance. So self-employed and independent contractors who have historically been locked out of the system are now able to apply. And it's been difficult for the state to create a system to include those people who have historically been, the system was made to sort of lock out, but they are eligible now. Sort of think about your small business owner, your hairdresser, those types of workers are now able to apply for unemployment insurance. They also have what's called a work sharing program. And that's part of this language that mirrored CARES Act language as well, which is almost basically what we're doing right now. A lot of telework, a lot of people who've had reduced hours, and a lot of non-traditional work arrangements being made, and then the UI system sort of capturing that for those workers who've lost too many hours and who might fall through the cracks. So the other federal provision that we're going to talk about has not passed Congress yet, but we heard about the CARES Act, or at least through some of that legislation that passed through Congress early on is where some of the stimulus money came from. So a lot of people are familiar with that, and we've kind of heard there's going to be somehow another round of stimulus funding, and the House version of that is the HEROES Act. So some of these unemployment provisions that we've been talking about are time limited right now. They would be extended, and a lot of the money that's coming from the pandemic unemployment assistance is coming from the federal government. So you would have potentially people who need that assistance much longer, and they'd be able to benefit through that through at least through January. It kind of depends on when you started, because you're going to exhaust a certain number of weeks and potentially have more weeks added through this legislation if it were to pass. This is the House version. I'm not sure if there's a similar Senate version. There's a similar idea of a stimulus package, I think, in the Senate. So I think everyone's sort of seeing right now how much longer this virus is going to last and how our economy is going to pick up when it does. So when it does subside a little bit. So be watching for new legislation from Congress. Because so many people have been applying for unemployment, we thought we'd give you a sort of a quick tutorial on applying for unemployment assistance. This is a little bit, I think Miranda mentioned, we're living in, very extraordinary times, and we don't usually do this same presentation, or we do a similar version where we sort of talk chronologically about employment from the time you're applying for a job to the time your job is ending, and we're sort of starting from the end and talking about a job ending. So it's not our favorite place to start, but it's so relevant to the times that we're living in right now. Most people apply for unemployment insurance online, and that is probably the easiest way to get your claim started, especially if you speak English. There are phone numbers. Because the phones have been so overwhelmed, there have been various days based on last name where certain groups can call in, and you can look up your last name and see which day would be yours to call in. There have been very long wait times to talk to someone on the phone. I think at the beginning of the pandemic, the state had about 9 people answering the phones for unemployment insurance, and now they have approximately 1,200, if that tells you anything about how many people they've had to staff and train and add to the phone lines for the number of people and the number of claims that they have had to handle. So, if you're going to call or apply online, be ready with your information, your basic contact information. I think they do have to have an email for you under one of the statutes. They have to have a way to contact you in writing. So your address, your date of birth, your social security number or USCIS number, and again, you're going to have a work history. You don't necessarily have to have worked for the same employer for your recent history, but you do have to have a steady amount of work history, and that's just so they'll know which employer to charge for the unemployment benefits. If you worked in other states, that's obviously relevant too. If you've worked in another state for a substantial period of time, you might have to apply for unemployment in that state. I know living in Louisville and close to Indiana, we've had to deal with that issue quite a bit. So this is a separate website than the website you go to apply for benefits, but it does have good information on the process for unemployment, and especially if you see in the corner right there, this is in English, but it can be Google translated, which I know might be important for some of your all's clients. There's FAQs, there's talk about the process. You can see the video right there. And there's a lot of information that's virus specific to some of these new provisions that we're talking about as well, that if you have questions, you can sort of walk through some of these pages online and have your questions answered without having to spend 6 hours of wait time on the phone, because I've definitely heard those stories recently.
So this is a screenshot of the website that we linked on the previous slide, kcc.ky.gov, and it has a link to the application itself.
And if you're having problems completing your unemployment application, or someone who you're serving is, again, there's that telephone number there. That people have been experiencing long wait times. People have been getting automatic notices that they are ineligible for unemployment, which may not be the case, because there are people who used to fall into a category of workers that were ineligible, and now a lot of that has changed, but the system did not change as quickly as the rules did. There have been people whose claim has not gone through the first time and they've been asked to refile, and they've had 2 or 3 claims pending at once, when I know for a long time the governor was getting on his 5 o'clock press briefings and saying, don't refile, but it's hard to do that when the system is telling you need to file again, and then the governor's telling you not to do that. I've had a lot of people who've had problems with that, but they've paid out a lot of benefits. It was kind of slow at first, and there have been a lot of people who have had individual problems with their specific applications that I know that that claims assisters are working through. There's on the call center, there's 3 different tiers of specialists who can help people over the phone, and I think it's tier 3 that has the most access and can actually get your account fixed, so to speak. There have been, there's a lot of places you can go to for help. We're looking at the physical. I'm looking at the link with the physical locations of the Kentucky Career Center. Those are not open to the public right now, but there are people in person who work there doing the same kind of work that they would be doing if they were assisting people in person. So there are a lot of people working on these types of claims and trying to get them processed and paid in compliance with some of these new laws. So it's been kind of a wild year in a lot of ways, and you can see that especially when you look at the state unemployment system and how it's been overwhelmed. I get an email every week with the job numbers from the federal government, and we still have tens of thousands of people applying and reapplying for unemployment every week. So the number's gone down a little bit, but it really has not slowed down the number of claims. So it would be no surprise to me if someone you're working with was having problems with their claim. You do have to be very persistent, reach out, use the phone, wait on hold, answer the phone when someone calls you back, because you can request a call back. And I know people who've been caught up by not being able to answer the phone, and use the email that that's given as well. We haven't seen a lot of this yet, but your employer or the Unemployment Commission can determine that you are ineligible for benefits and deny your benefits. So your employer can say, can dispute the reason that you gave on your unemployment, saying that maybe it was COVID related, and the employer saying, no, this person voluntarily left, we were still open, and this person quit, which is a reason that could potentially be a reason for denying someone's unemployment. If you are denied unemployment, you will receive what's called a notice of determination in the mail, and we've provided a little snippet of that at the bottom that explains your appeal rights. So, this is a determination made by the state. So in order for due process to apply, they have to give you notice, which is the notice of determination, and a right to be heard, which is the appeal rights. And in order to appeal, you have to do so within 7 days of receiving that notice of determination, and you have to include certain information that's listed here. Your claim reference number, your last four of your social security number, your contact information. You can appeal it, you can fax it. I've heard recently people discouraging fax, but I think I've done it before. You can call the Unemployment Appeals Branch. They process these hearings. I've done some of these types of hearings before. I know the Legal Aid Society of Louisville and Legal Aid of the Bluegrass can do them as well. So you can look up your local legal aid office, or you can look at our organization's webpage and figure out who might best be able to work for you there. But you do have the right to appeal. It goes before what's called an unemployment insurance referee. It's not really a judge, it's an administrative proceeding. And it can be done by teleconference. So you would be on the phone, a representative for your employer would be on the phone, your attorney would be on the phone if you have one. They can have a legal representative on the phone, but it's a lot like a hearing in that you can talk about documents, you can have witnesses, you can present evidence. It's a little bit more informal than what you would see in court, but it is a hearing, so to speak, that's recorded, and then the referee makes a decision. There's a lot more appeal rights after that, but that's the first one you would have to get through after you receive that notice in the mail. So, and then they can reverse, and you could get benefits after that.
Okay. Did you have something else, McKenzie?
No, I think you're going to talk about a little bit of a different side of this. We've been trying to cover a lot of these virus-related topics under the typical structure they fall. So I've been covering unemployment. You're going to talk about medical leave, and then we're going to kind of go back and we're going to talk about where those two things sort of cross over, which is health and safety.
Right. So first I want to talk about just medical leave in general, even without the pandemic, and then I'll go into what's specific about now during the pandemic. So even in regular times, we have the Family Medical Leave Act, and to be eligible for this medical leave, an employee has to have worked for their employer for at least 12 months. They have to have at least 1,250 hours of service for the employer during the 12-month period immediately preceding when they take the leave. And they have to work at a location where the employer has at least 50 employees within 75 miles. So What are they entitled to? Eligible employees may take up to 12 weeks of unpaid leave under the FMLA in a 12-month period for one or more of the following reasons. They can take leave because they had a birth of a child, or a child was placed with them for adoption or foster care. They can take leave to care for a spouse, son, daughter, or parent who has a serious health condition. They can take leave for a serious health condition that makes the employee themselves unable to perform the essential functions of his or her job, or for a spouse, son, daughter, or parent of a military member on covered active duty or called to covered active duty status. So what's exceptional right now is the Families First Coronavirus Response Act. So the provisions of this act will apply from the effective date through December 31st, 2020. And they apply to certain public employees and also private employers, certain public employers and also private employers with fewer than 500 employees. But businesses with fewer than 50 employees may qualify for an exemption. So generally, this act provides that employees of covered employers are eligible for 2 weeks or up to 80 hours of paid sick leave at their regular pay rate if the employee is unable to work because they're quarantined or are experiencing COVID-19 symptoms and seeking a diagnosis. It also covers 2 weeks or up to 80 hours of paid sick leave at 2/3 the regular pay rate for the employee if the employee is unable to work because of a bona fide need to care for an individual subject to quarantine or to care for a child whose school or child care is unavailable for reasons related to COVID-19 or experiencing a substantially similar condition. It also covers an additional 10 weeks of paid expanded family and medical leave at 2/3 the regular pay rate if the employee who's been employed for at least 30 days is unable to work due to a bona fide need to leave to care for a child whose school or child care is unavailable for reasons related to COVID-19.
So I'm going to talk about the next intersection between really merging the last two topics that we've talked about, which is unemployment and family leave. So a lot of businesses have been closed during the pandemic, and a lot of people have been forced onto unemployment, or they've had the ability of what Miranda mentioned to be put on paid leave through their work and been able to maintain their employment and benefits. So what you're going to see is when people are going back to work more, they're going to have to look at what types of policies their employer has implemented to maintain a safe workplace. So, generally in our normal slides, when we talk about safety in the workplace, there are a lot of, potential hazards in the workplace. There's a lot of different types of workplaces out there, and a lot of potential safety concerns, a lot of ways for people to get hurt. It's ultimately the employer's responsibility to both maintain a safe workplace and then to cover employees who have been injured on the job. But it is important for employees to observe and follow safety guidelines and the trainings that have been provided to them, because ultimately avoiding an accident and avoiding an injury is probably the best way to go for a worker, especially someone who uses their body in the workplace and needs to maintain those skills over a long period of time in order to work. There's a lot of different types of workplace injuries out there. Falls are the most common workplace injury. We always encourage people to report unsafe working conditions, and again, play that part in maintaining a safe workplace, even if the employer isn't going to do so. almost every employer, really every employer in Kentucky, is required to maintain some sort of workers' compensation coverage. There are provisions for workers or some employers to maintain self-insured policies, but most employers have outside insurance through a group like KEMI, Kentucky Employers Mutual Insurance. That is because they are ultimately legally responsible for their employees' injuries on the job. They know that they have to have this coverage in order to pay those claims. That's sort of the general framework, and that general framework is the same, and it hasn't changed very much, except we have these extra guidelines from OSHA and the CDC, the OSHA being the Occupational Safety and Health Administration, and CDC being the Centers for Disease Control and Prevention. They've published guidance for employers guidance on how to protect their workers from COVID. The problem is that is voluntary guidance. So the administration and OSHA could have made this guidance mandatory. They could have put what are called standards or safety standards in place and made this mandatory. They did not do it, so it is voluntary. So it is they're not legally bound and could not be reported. You can report this sort of violation, but it is not. It's not enforceable like general OSHA standards are. Some of this guidance is some of what we've seen in other types of sort of the daily business that we do. Going to the grocery store, for example. The social distancing, I think we're all familiar with. People wearing masks. Flexibility in where and when to work. So, for example, if you're working in an office setting, allowing your employees to work from home during this time, or staggering their work hours so you have less people in the office and less people in contact with each other at a time. Frequent hand washing, always important. Sharing equipment, or at least cleaning and disinfecting facilities where there is shared equipment. Better cleaning and disinfecting. Sick leave when it's necessary. I think Miranda talked a lot about what the federal government is doing, but also pushing employers to look at their own policies if they're not generous enough in allowing for people to care for or take care of themselves when they've been exposed to this virus. There's a whole other set of guidelines out there for healthcare workers because of the masks, the visors, all the PPE that they're expected to wear, and how that workplace is a lot different than our sort of office setting or other workplaces. I know if there's different guidelines out there for per industry. For example, meat packing have had people on the line where they've been very close to each other. So every workplace is different. But we are encouraging everyone to follow this voluntary guidance and for whatever that means for a particular workplace. So normally in this presentation, we talk a lot about employment. We talk a lot about discrimination, especially for immigrant workers, because there are a lot of potential for discrimination on the job. There's a lot of potential for discrimination based on the color of someone's skin or their national origin. Sometimes even language can be discriminatory, but not always. But a lot of potential pitfalls in there, and we normally talk about it quite a bit. But when we talk about retaliation, sometimes retaliation can mean that someone complained about discrimination on the job, and for whatever reason after that, they were demoted, they're paid less, they were fired, or they're being treated differently since they complained or made that formal charge of discrimination. That's a type of retaliation, and it's because we haven't provided you with that other framework about discrimination, it's hard to talk about in more detail, but just know that that's a part of retaliation too, and it's not just safety. It's also discrimination. But basically, these are protections and making it illegal to fire someone because they're complaining about either safety or discrimination. I always encourage people, if they think an incident that they were involved with could be a retaliatory action, and they're going to come see someone like me, to have a detailed record of dates, names, places, when things happened, because in order for me to tell your story, you kind of have to know what the story is, and some of those interactions can be important and complex, and it can kind of be easy to forget who was standing there when something happened. So just being sure to keep that in writing. Kentucky and federal law, because Kentucky runs its own OSHA program. So we could be a part of OSHA, but we're not. We actually have what's called Kentucky OSH, which is the Kentucky Occupational Safety and Health. A lot of our program has to be as good as the federal. So all of these protections are still there, but they sort of can come from different places, either Kentucky law, federal law. It is illegal to retaliate against someone for exercising your rights, such as filing a safety or health complaint. There's been a little bit of case law there that's a little bit nuanced. It does generally have to be a serious safety or health concern. Participating in a worksite inspection, or reporting a work-related injury or illness. Some work-related injuries or illnesses are required to be reported by OSH and required to be reported in a certain amount of time. So that's a really important part of injury prevention. Some safety and health activities could be protected under the National Labor Relations Act if the activities are for what the law calls mutual aid or protection. So again, you can have that. It's also called protected concerted activity. So anything where employees are talking together about their wages or working conditions, if it's health or safety related, they can be protected under that act if they are retaliated against later. So a couple of places you can sort of go to, and a lot of this is the law generally, but if you're interested in how this is, I can sort of tie it into how it's COVID and pandemic related, because a lot of people are going to be asking questions when their employer is ready for them to come back to work. They want to be sure that they're going to be safe there. They want to be sure that their employer is following the rules, whether they're going to be able to be distant or have some sort of barrier between them and customers, for example, or that they're not going to be standing on a factory line closer than 6 feet to their coworkers without some sort of partition or barrier, and whether that work without those protections or without following that guidance that we've been seeing from OSHA and the CDC, whether that is returning to a truly safe working environment that they're entitled to under the law. There's a lot of places where you can report safety violations, and I sort of brought up the different complaint forms that you can use that are on the Kentucky Labor Cabinet's website. Some of this, especially retaliation, is also actionable under state law. So you could also talk to an attorney about some of these. But you have the Kentucky OSH complaint form, which is a form you could print out and mail in to the Labor Cabinet in Frankfort. Or you could also use the federal OSHA e-complaint form. So if you clicked that form, that would bring you to an online form that, again, is run by the federal government, but because Kentucky has its own OSH program, that goes directly back to the state. They basically just forward the email that comes in their mailbox with the complaint form and send it back to Kentucky OSH inspectors. So you have a couple different options there on how to make complaints. There's also been, for COVID-related complaints about businesses and employers not following the guidelines that have been set out by the CDC. There's also been 1-800 numbers that you could call there and report businesses and employers that are not complying with recommendations such as social distancing. So you have some COVID specific resources there, but really these resources that are provided here are specific to whatever whatever time we're living in, COVID or non-COVID, or just injury prevention and safety related.
So we've covered the really COVID specific information already, but one of the things that we've noticed is that despite the fact that a lot of workers are really hard up right now to have a job and get paid for, and have disposable income that they can use to pay rent and bills, there are still some employers out there right now that are hiring people to do things that they're still allowed to do, that they're not restricted to do under the social distancing guidelines. Things like landscaping or contract work, construction, painting, things like that. That there are still jobs out there where employers are taking advantage of employees, and they may not be paying them or paying them the correct amount. And we're still getting complaints from employees, from workers who aren't getting paid correctly, and have a wage theft complaint, basically. So we do want to take this time to go over some basic wage and hour laws and information about what can a worker do if they're being taken advantage of in these ways. So basically, minimum wage is $7.25 an hour, and employees must be paid at least the minimum wage that was promised, at least minimum wage and at least the wage that was promised to them. So even if minimum wage is $7.25 an hour, if when the employee was hired, they were promised $10 an hour, then they are supposed to be paid $10 an hour. And this is true regardless of immigration status. So if someone is a tipped worker, then the minimum wage for them is $2.13 an hour, but they still have to earn the average $7.25 an hour when you add their tips onto their wage. So if they aren't earning $7.25 an hour with their tips taken into account, their employer is supposed to compensate them the rest so that they still make an average of $7.25 an hour, but the minimum that they can make on their wages is $2.13. And in Kentucky, employers cannot have tip pools. So that means that they can't, employees, like at a restaurant, for instance, can't be part of a tip pool, can't share their tips with other employees unless they consent to do so. The employer can't mandate a tip pool. So overtime is when you're paid time and a half for any hours that you worked over 40 in the same week. Kentucky also has 7th-day overtime, so if you work 7 days in a row, you could be paid overtime. But agricultural workers are exempt from minimum wage and overtime rules. Domestic workers are exempt, and salaried employees are exempt. All employees must be paid on time for all the work that they perform. And sometimes people ask, well, do you count the time of me driving to the job site? That depends. The law does not define what work is, but it's any activity that benefits the employer. So generally, if you're commuting to work, that's your time, that's not work time. But if you're driving between work sites, then that would be considered job time, work time on the employer's dime. To give an example. So if you're working with clients, advise them, especially immigrants and clients with irregular schedules, to record all their hours, all the hours that they worked, to note it somehow, whether it's on paper, in their phone, whether if they don't want to type it or write it, they could dictate a recording into their phone or something, send text messages to themselves, but somehow document their hours. And I say immigrants especially because they're so commonly taken advantage of because employers think they can get away with not paying them. And also clients with irregular schedules, because it's so much easier for employers to get by saying, well, you didn't work those hours, because their schedule is not predictable and not something they could easily say, well, yes, I do, I always do, because it's irregular. So please encourage clients to document their hours and document your own hours. So wage theft, when someone isn't paid what they were promised or isn't paid minimum wage or overtime, this is something that we help with at Kentucky Equal Justice Center. In Lexington, for many years now, we've had a monthly wage claim clinic. It's on the third Wednesday of each month from 4 to 7 p.m. and people can call for an appointment. We generally would take walk-ins, though right now with COVID-19, we're avoiding meeting people in person, so we're setting up phone appointments with people. But even in general times, it's best to call for an appointment so we can plan accordingly for how many people we're going to be working with that day. But please encourage folks experiencing wage theft or potentially experiencing wage theft to call us for help. We've also this year in 2020 started a wage claim clinic in Louisville. This is our second trial run of that, and it is on the second Monday of each month from 10 a.m. to 1 p.m. So we have a number here that you can call if you serve people in Louisville.
So I'm going to wrap us up a little bit by talking about a concept that can be kind of technical and boring, but it's also really important to accessing a lot of the coverage under these laws that we've talked about, and that's called misclassification. There's a couple different types of misclassification. We're going to be talking about independent contractor misclassification. There is another type of misclassification that can happen in employment law where you're paid a salary rather than hourly. Salaried workers, you can pay someone a salary under federal law, but there's certain requirements for that. And if someone pays you a salary, you work till the job's done, and if you work 60 or 80 hours a week and you really needed to be paid by the hour, you would have lost out on a lot of overtime compensation. But we're talking about something called independent contractor misclassification, which is basically 1099 work. The way I sort of explain it to most people is an independent contractor relationship is when something breaks at my house and I call someone to come fix it. They're an independent contractor, or they might be. But they are to me. They own their own business. They bring their own tools. They might have their own license if it's required for the type of work that they do, for a plumber, for example. They come, they assess my problem. I don't have to give them anything else. I pay them, and the job's done. And that's sort of what an independent contractor relationship is or should be. There are a lot of legitimate independent contractor relationships out there. I've been an independent contractor working for a law firm before, where it was a short-term arrangement, and I was paid by the hour and not guaranteed a lot more than that, and I had my own workspace and my own knowledge and skill and background that I brought to that area of law. So I've definitely done this before, but it can also be a way for an employer to try to skirt some certain employment statutes. And we've already said right now that independent contractors are not being penalized under unemployment, and they actually still qualify for unemployment right now. That's normally not the case, and it's kind of a special circumstance for the virus. But normally, if you're an independent contractor, you're not having your taxes paid out for you. You don't qualify for workers' compensation coverage or unemployment, and you don't qualify because you don't fall under the definition of employee under these statutes. You don't qualify for a lot of the protections that we've talked about. You don't qualify for benefits or just general protections under the federal minimum wage and overtime. You don't qualify for any kind of benefits the employer offers, healthcare, any of that stuff normally. So again, it can be a really damaging situation for an employee, especially if they are under the control of the employer and they're reporting at certain hours, they're not exercising their own discretion, they're not utilizing any particular skill. So it's something that we definitely want you to watch out for in the workplace. So with that general framework in mind, I think it sort of opens us up to this next point, which is Kentucky is what's called an at-will employment state, which means you can be fired for any reason, no reason, a good reason, or a bad reason, as long as it's not an illegal reason. So a lot of people call and they want to talk to an attorney about an employment law issue, and they say, I want to sue for wrongful termination. And that's great, but wrongful termination is not something that I could put in a legal document and it would be recognized by a court. You have that's not really a reason to fire someone. So usually what we're talking about when we're talking about some sort of employment law action or some sort of illegal action, we're talking about exceptions to the at-will doctrine. So exceptions can be a contract, which is a written contract of employment, which means instead of at will, your firing would be for cause, because that's what a contract is. Discrimination we've talked about a little bit, but discrimination again is an illegal reason to fire someone. So it's illegal to fire someone based on their race, their gender, their age if they're over 40, their religion, their national origin, in some counties their sexual orientation. Again, we've talked about retaliation. It's illegal to fire someone and retaliate against them because of complaining about discrimination or safety and health in the workplace. A union is really similar to a contract because the contract is between the union and the employer, and it's the collective bargaining agreement. And there are a lot of employees in that situation who would be the beneficiaries of that contract. So their wages, benefits, and discipline and other items relating to their employment are governed by that collective bargaining agreement and not necessarily Kentucky law. You do have to, the collective bargaining agreement has to be more favorable than Kentucky law, but it's a different document, therefore a different standard and not at will. So the last thing, we've talked about a lot of different topics and a lot of different resources of where you can go for help. And everything that we have talked about, we've tried to talk about it as we've gone through the presentation, is there is a state and or federal agency that can help you or the people, the clients you're trying to help with these issues. You can also consult with a private attorney, such as KEJC for low-income people, and private attorneys in case someone might not be able to meet our income threshold. So we have our information on our slides. We have all of these state and federal agencies, OSH, the Labor Cabinet, the U.S. Department of Labor, the Kentucky Commission on Human Rights, the Equal Employment Opportunity Commission. All of these, there's a little bit of nuance to each one. You could certainly call us just to figure out which agency would specifically address your claims. For example, USDOL would be a better entity to make a complaint about an overtime violation, would be better than the Kentucky Labor Cabinet to do that. The Kentucky Commission on Human Rights, or maybe even if you live in Louisville or Lexington, the local commissions there would be better to enforce a violation of employment based on sexual orientation, because those protections are given by ordinance rather than state law. And then for large employers that are active throughout the country, you actually have to complain to the Equal Employment Opportunity Commission before you can file a lawsuit in federal court, not state court, but federal court. And they have to give you a right to sue letter. So you would want to complain through that agency rather than the other ones if you wanted to sue an employer in federal court. So there's a lot of nuances there. That's why we have attorneys to sort out a lot of these differences. Workers' compensation is a totally different system. It's an administrative system. You don't file with the court.
Please excuse the technical difficulties. As McKenzie was saying, with workers' compensation, you don't have to file with the court. You instead file with the Department of Workers' Claims, either with a paper application or with an attorney. And so we've covered all of these different agencies, and I've put our own contact information back on the screen. So if you're not sure which agency to contact with you or your client's specific issue, or if you have specifically a wage claim or a retaliation or human trafficking, labor trafficking issue, you would call us. We'd love for you to call us for help. In the Lexington area, we do intake of cases for wage theft with my phone number that's listed there. I do the intake for the wage claim clinic. And then in the Louisville area, Liz Perkins does our intake for our wage claim clinics there. Of course, McKenzie is our employment law attorney, so she actually handles the cases, but Liz and I do the intake, and then if it's a issue that's not specifically wage theft, it'd be best to call McKenzie directly. And McKenzie and I do both speak Spanish, and if there's another language required, we can get a language line interpreter over the phone. So we're happy to help. We hope that you have a good rest of your conference, and that you've enjoyed it, and that you've gotten a lot out of it, and that we will be seeing each other in person within the next year. Thank you.